Hello everybody, and a very warm welcome to this month's regulatory and compliance update. I've not known such a busy month for a long time in terms of regulatory news, so we've got plenty to cover. But before I go on, just to let you know, we have changed the format of the slides. They are now AI produced, so I'm very busy at the moment with AI. I hope you like them. Do let me know what you think, because if we need to go back to where we were, then happy to do that. But let me know what you think. There's a lot more detail on there. I'm not going to go through everything, but I think for a reference document, it's pretty good. So do let me know what you think, please. My email address is there. Okay, so the first slide showing you what we've changed in terms of administration. If you have any questions, if you want to put those on the system, and I'll pick those up at the end. If you're a solicitor, it's A2 for competency. The session is being recorded, so that will be available after the webinar. And please feel free to use it internally for training purposes if you like. I have uploaded the slides, so if you want to pick those up from the system already, then you can do. As I say, I've not been so busy as I have been in this particular month, particularly around LinkedIn. I've done a lot of articles around all the topics that we're going to be discussing. So please, if you're still not connected with me or looking at what I'm doing on there, then please do go to LinkedIn. And although the slides have changed, we still have the links at the bottom of each slide. And right at the bottom, don't forget to click on Save a Seat as well for future webinars. So what have we got going on in terms of webinars and events? So we've got Tom Blandford, who is a financial specialist. He's going to be joining me on the 13th of November, looking at, is your firm financially sustainable? That is a big issue at the moment because post SSB, and we'll be covering that in a moment, the SRA is going to be looking a lot more at the financial stability of law firms. So I think that might be one that you really want to come and have a listen to. We've also got our normal horizon scanning session, which is looking at what's coming in 2026. And I think it's going to be a very busy year, particularly around the post office and all the things that are coming out there. I do wonder if this is going to be 3 hits and you're out, because for the SRA, in terms of we've got Axiom Ints that we've had in last year, I think it was. We've then had the SSB scandal, and I think we will see the SRA being dragged into the Horizon scandal as well, the sub-postmaster scandal as well, because of the lack of supervision of the solicitors involved in that. So I think we're going to see a lot of stuff coming out next year. And our next AML update is going to be the 22nd of January. Again, lots of things to discuss there. So please book yourselves onto that. What we've also got coming up next week is an Ask Me Anything with legal AI expert Uwais Iqbal. I did one of these a few months ago, and it went down very, very well. And a lot of people have said, can you rerun it? So we are rerunning that again. So please do come to that if you want to talk about AI. If you want to put your questions in, again, just send them to me. Or if you want to attend and then put them in, then please do. This is a LinkedIn live event rather than one of the ones that we normally do. So do make sure you click on the LinkedIn link at the bottom there and get yourselves booked in for that. And failure to prevent fraud, we are running a particular training course on that. So if you're interested in that one, that's the 28th of January 2026. So this is the first of a series of new training events that we are putting together. There is a cost to it, as you can probably see. But yeah, do book in for that one if you're interested. But let's move on to the main event. Lots of things going on here with SSB, as I say. So this is where the SRA failed its statutory duty, and we have listed a number of the breaches that the SRA committed here. So again, we're looking at protecting and promoting the public interest. It didn't do that. Improving access to justice, it didn't do that. Protecting and promoting the interests of consumers, it didn't do that. And promoting and maintaining adherence to professional principles, it didn't do that either. So let's just have a look at some of the issues that were found. I'm not going to go through all of them. There is a list as long as your arm, but I'm going to pick out some key ones here. So it did not adequately link or connect multiple reports showing patterns of concerning behaviour. Goes back to what I was just saying a moment ago about financial stability. That was part of the problem because it didn't pick up on the financial issues that were going on within the firm. So, as I say, the SRA is going to be looking a lot more at that. It closed many client reports as service complaints without recognising serious regulatory issues. So, in effect, it was basically saying nothing to do with us, Gov. Go to the legal ombudsman and see what they say. When in fact it was everything to do with them. There were mixed warning signs, so it received over 100 reports about SSB between January 2019 and March 2024, but failed to take effective action. Says a lot about a regulator who isn't taking effective action. Where was its focus? Was it focusing too much, for example, on what many would see as tick box compliance with AML requirements around firm-wide risk assessments and things like that? Leave that one for you to determine. It failed to recognise patterns despite SSB being on a watch list from November 2021. So again, it shows the SRA was fully aware of these things, but actually didn't do anything about it. In April 23, forensic investigation revealed SSB owed £128 million to litigation funders, yet concluded there were no financial stability issues. Quite clearly there were, but it didn't pick them up. And then there was little evidence of considering client vulnerability when assessing report seriousness. So one of its core issues that it sort of looks at the profession for, it failed to look at, and that is the vulnerability of clients. So it has well and truly had its knuckles wrapped. Unfortunately, we haven't seen the appropriate departures of the chair or the chief executive, and I'll come on to that in a moment, although the chief executive has now gone. He left last Friday. So let's have a look a little bit more in a little bit more detail here. So we talked about how things failed. So there was artificial chasms in terms of the complaints, conduct complaints, disconnected data, whistleblowers ignored, centralized risk and intelligence hub. So this is something which has been recommended by the Legal Services Consumer Panel. So they have said that there should be a joined up risk and intelligence hub. Clearly the intelligence was going into the SRA, it just wasn't being used in an appropriate way. But what I would say is that some of us saw this coming years ago. I remember when I was at Reliance, the business which I was running, we had a law firm that basically signed up for the product. They had all the contracts and everything else, but they then didn't pay their bills. And so we basically tried to get them to communicate with us and things like that. They wouldn't do so. And therefore, we went to the SRA and said, look, SRA, I think you need to be aware of this because it shows that there are integrity issues, potential honesty issues, bringing the profession into disrepute. Are they financially unstable? And what did the SRA do? They turned around and said, nothing to do with us, Gov. This is basically a commercial dispute. Had they basically looked at that, they may have found some of the concerns that we had, but they chose not to. And that is what we've seen in relation to other issues, again, around SSB. As I say, we had that issue at Reliance. We don't normally refer people to the SRA, but I just wanted to use that case as one many years ago that showed how the SRA was not trying to join up the dots. The COLP exodus. Now, this is one which I've been looking at very closely over many years. In fact, ever since it all came in 2013. And I have to say, I've been really surprised that the SRA has not done a full thematic review of the COLP regime. But I've allowed that to sort of go. But I then put in a Freedom of Information request very recently. And I was really surprised at the numbers I got back from the SRA. So when we talk about, COLPs, we're talking about one in each firm. So we're talking about just over 9,000 COLPs. But when you look at the turnover, and the average turnover is 1,071 a year, I mean, that is a very, very high turnover. And so I was asking the question, what is the turnover of COLPs, but also how many resigned due to conflicts with their firms, how many were dismissed for raising compliance concerns, how many current COLPs lack the authority to challenge leadership, and how many have restrictions preventing them from doing their job. This is live stuff, bearing in mind the COLP is the main person looking at compliance within a firm. Having that level of turnover really raises, real concerns. Now, I'm still waiting for some of the answers to come back from the SRA, and I'll give you updates on that. But I just wanted to really raise, this one, because a lot of COLPs have contacted me. I've had some who have resigned as a consequence of conflicts with their firms in terms of what they need to report. They haven't had the support, they haven't had the training. There's been some real issues. And so, this is a live issue which I think firms need to be aware of. So the SRA Compliance Conference, lots of things happen there. So again, I'm not going to go through some of the small print. I'll leave that to you to sort of have a look in your own time. But multiple apologies. Yes, on this occasion, we actually had multiple apologies. We did not have the chair this time turning around and saying, it's history, let's move on. So there were multiple apologies, but there were no resignations. And the board itself had said, the reason we don't want any resignations is a need for continuity. What continuity in poor practice? Clearly, many of us at the conference were saying there should have been head rolling. Thrown under the bus. So one of the comments that was made was a number of top-level departures since the scandal, which left us with the sort of belief that what they were doing was saying all those people at the top of the SRA who had now left were the ones to blame for all of this. But actually, the chief executive was still sitting next to the chair. And okay, he was leaving that Friday. But at the end of the day, he has left under a retirement agreement rather than going because of misconduct. So there was a lot of questions around that. The chair is still there. So, I would be interested to know whether some of those people that have now been thrown under the bus actually think they were to blame for it, or whether they will take issue with the SRA over what it's actually said about them. So who pays for all of the change that's going to be undertaken to sort of get us where we need to be, or certainly get the SRA where it needs to be? Well, unfortunately, it's going to be you through your practice certificates. And so, who wins in all of this? Well, nobody really. The data paradox, the chief executive, it sort of made me laugh while I was there. Chief executive said the SRA needs more data, but the report showed the SRA had plenty of data. It just didn't join up the dots. And so, we've got this sort of, well, it wasn't our fault. It was the lack of data and all the rest. No, you had everything. That you needed to make these decisions. You just didn't use it in the appropriate way. The bombshell, as you can see there, many of you will now know that the SRA will lose its supervisory role in terms of AML. That is now going to move to the FCA. Before any of you ask when, I don't know. I don't think anybody knows yet. Obviously, as you can imagine, with a real change like this, it's going to take time. I think you'll probably be 12 to 18 months before you see any real shift towards the FCA. The reason I say it was a bombshell was because the SRA didn't know before it was going to happen, and therefore the moment we sort of got out of an AML session, having been promised that they would tell us what this bombshell was going to be, we hadn't heard anything. And then we moved into sort of lunch, and we were then hearing on the grapevine what had been going on. And that's when it came out that the Chancellor had done what she had done. But it basically is a stunning vote of no confidence in the SRA, because it was looking to take over the supervision of all the legal sector, in effect. The fact that it hasn't says, well, it speaks volumes. I put the rubbish moment because when the chief executive and the chair were doing their session, right towards the end, somebody did in fact shout out rubbish. And I had to put out a LinkedIn post to say, just to confirm that wasn't me, because I think many people, when they see the LinkedIn posts that I do, would think that in fact it would have been me, but it wasn't, although I did actually agree with what was being said there. Regulatory confusion. One of the things that I've been trying to get some clarity on is the own interest conflict position around the handling of complaints. So I took the opportunity to go and talk to the SRA to say to them, what is the position here? And they said, yep, you're quite right. And what we've provided in advice to you is quite right. And that is one of the first things you should be asking about when you get a complaint is, can we actually handle it? Because there could be an own interest conflict, or certainly a significant risk of such. I thought, fine, okay, I now have the knowledge that I need. So I then went to the legal ombudsman's desk, and there was a chief ombudsman there. And I basically reiterated what I'd said to the SRA and what the SRA had said to me. But she then said, we don't agree with that at all, because that could actually delay the handling of complaints. It could cause confusion with the complainants, because it may be a letter coming from an external third party handling a complaint where it was felt there was an own interest conflict. And so I said, well, maybe you two need to get together and sort yourselves out. And, you need to come up with a consistent approach with all of this. So unfortunately, that is where it's left. I have made contact with both the SRA and the legal ombudsman, asking them to let me know what's going on. But to date, I haven't had anything. So I'm not quite sure where we're supposed to go, where you are supposed to go with that, and where I'm supposed to go with that in terms of communicating things. But I'll let you know as soon as I get something on that one. But the atmosphere there, it was basically very heated, particularly when we came to one of the sort of the breakout sessions. And of course, we weren't allowed to ask open mic questions of the chief executive and the CEO. So people were basically using the open mic sessions that we did have to then challenge the senior people from the SRA. So the head of ethics and the head of investigations at the SRA got it both barrels. Again, I did an article on a detailed article on the compliance conference. So if you want to pick that up on LinkedIn and see what else was going on, then by all means do so. So lots to think about there. SRA AML annual report. So we saw that come out, I think it was last week. And here are some of the high level numbers. So 32.4% of firms were totally non-compliant, not just a little bit, but totally non-compliant. Just to give you a little bit more insight into that, in 2023's report, 78% were partially or not at all compliant. This year, 2024-25, 86% were partially or not compliant at all. So you can see that the profession is going backwards rather than forwards, if that data is, is to be believed. So I think, you can see these sorts of report figures going to the FCA, and they're going to be thinking, right, okay, when we get hold of this profession, we are going to really go to town with it. So I think people really do need to start looking at making sure that they are compliant with the existing regime. The SRA has in effect said that as long as you are doing what you're supposed to do with us, then you won't have a problem with the FCA. But as we can clearly see, there are some firms who are either not doing it at all or are not doing it to the level that the SRA would expect. So this is a real warning. So I'd really take heed of that and start preparing. To say, I've talked about 12, 18 months before the FCA is likely to take over, but it could be sooner than that. You just don't know. So we do need to be moving fairly quickly. And by the way, we need to, you need to ensure that you are compliant now, because the SRA will still be doing what it's been doing normally. So they're not taking their foot off the accelerator in terms of, enforcement and investigations and things like that. It's business as usual as far as they're concerned at the moment. So take that into account. But it's not just law firms. We've got the same issue with the CLC as well. So it's just reported that 54% of its firms were totally non-compliant, with 37% being generally compliant. So you can see the real issues across the whole sector. And so again, I think that message that's going to come out from the FCA is, as a sector, you are not doing what you're supposed to be doing. And I do wonder whether, in fact, this data had already got to the government, and the government was saying, the sector can't look after itself, we now need to move it over to someone else. Now, there's all sorts of issues around, does the SRA know the legal sector and all those sorts of things? Well, time is going to tell. In terms of the transfer, then, I have done again a LinkedIn blog, so do pick that up if you want more detail. And, apologies for the sort of small print here. But you can, I wanted to put this together so that you can start to see what the current approach, i.e. the SRA's approach to AML compliance is, and then what the FCA firms are seeing in terms of compliance. And of course, one of the things is that the FCA has the powers for criminal prosecution, whereas the SRA only has the powers for regulatory prosecution. So you're now moving into, or going to be moving into, a very dangerous sector in terms of non-compliance, where, is the and it's a question I ask now, is the FCA going to be prosecuting on a criminal basis rather than just a regulatory basis? Now, if it needs to get its message home, then I will suspect there will be some firms who will be pursued on a criminal basis. And so we really need to ramp up the, what we're doing and making sure everything is where it needs to be. Again, I'm not trying to put across the fear factor here one moment, and many of you will know, this is not about fear factor. This is saying this is reality, and therefore, please don't shoot the messenger. I'm just trying to prepare the ground for what is coming. The LSB launches a major review. So this is obviously Mazur and the fallout that we've had from all of that. So it's going to be conducting a big review into this, because a question I've been asking is, well, fine, okay, people are now moving things forward, but how did we get here in the first place? The Legal Services Act is 2007. We're now 2025. How were things allowed to develop in the way that they have done, so that we then get to a court case and they say that, in effect, everybody's not been doing the right thing for X number of years? So the LSB said it would undertake a review to examine how approved regulators and regulatory bodies ensured that information on conducting litigation was accurate and reliable. CILEX and CILEX Regulation have both been accused of giving incorrect advice in the past. And the SRA has done too, because the case that the Mesur case itself, one of the law firms involved in that actually self-reported to the SRA, and the SRA said, you don't need to worry about this, you're doing all the right things. And then when it went to court, the SRA then went back on the advice that it had given. So the SRA is, in there as well. The spokesman did not hint that any disciplinary action could result, saying our review will help us all learn lessons and maintain clarity and confidence in the regulatory framework. Where have we heard that one before? So when it talks about disciplinary action, it's talking about disciplinary action against the regulators. But, as we've seen with Axiom, SSB, there's been no real accountability at the top of these organizations. And I think that's what we need to see. All they do is move on and then leave everything, as is. I really feel sorry for the new chief executive of the SRA, because she's got a poison chalice to pick up there. So, conduct of litigation. So this is the Law Society's practice note. So I would pick this up. So as I say, there's a lot of things coming out of Mesur, people sort of scrabbling all over the place to try and find out what's going on. We've got the regulators, the professional bodies, representative bodies sort of coming out with their views and everything else. So, there's a lot of stuff going on, and I'm going to try and give you what I've seen so far. But yeah, have a look at the Law Society practice note. Make sure, as I've put at the very bottom there, tick box oversight is not sufficient. You need to have the relevant evidence to show that somebody is doing things that they are supposed to be doing and not doing what they're not supposed to be doing. So evidence is going to be really key around, is this person authorized to do litigation or aren't they? So your note's really important. I was listening to a webinar the other day run by the SRA, and it's as a follow-up. It's a web-based compliance conference, in effect. So for those people who couldn't actually attend the live one, it's now that. And what I was interested in was the SRA saying that they had a question, somebody saying, should I self-report to the SRA on the basis that either I or someone within my firm has been undertaking litigation when they shouldn't have been? What the SRA said was that if somebody self-reports, each case will then be looked at on its merits, and not to assume that a report will lead to an investigation or enforcement action, which suggests to me that actually people should be self-reporting and then letting the SRA take whatever action, or not as the case may be, it feels is appropriate. I think the best practice advice that I can give is self-report and then see where things go from there. Because if you don't self-report and then the SRA turns around and says, well, you should have self-reported, you're going to have more difficulties. So whether you're flooding the SRA or not, for your own safety, I would be self-reporting and then letting the SRA determine from there. Not an easy decision, but I think it's one you're going to have to make on the hope that the SRA will see sense in terms of, well, look, we left the regulatory regime and landscape as it was. We should have picked this up, and therefore we're not going to have a go at people who thought they were doing the right thing, but as it turns out in this court case, weren't. One hopes that the SRA will take that sympathetic view, but unfortunately you never know with the SRA. STEP is also taking steps as well. So it's trying to get an understanding from the government in terms of probate rules. But basically what they are, so they're doing that. So there's another slide here I was going to come up to. So this is again, a wake-up call. So we've now had a real-world impact. So this was a court case in Oxford where the firm was trying to claim £3,000 and basically the judge applied Mesur and reduced them to less than £500. So you can see that we're now beginning to see Mesur having an impact on this. with the judge saying this has certainly scared a lot of people. You're too right, it has, and I think understandably so. This is quite an unholy mess which really needs sorting out. Tell us something we don't know. So yes, we need to be very, very careful on this one. One of the interesting things I got from the compliance conference was I was talking to an insurer about what is their view on all of this, and should firms be basically notifying their insurers on all of this. And I really didn't get an answer that would have helped firms. So I think what I would suggest is ring your insurer and basically ask for their views. And while we're talking insurers, Howden has warned on client contact protocols. So, as it says there, law firms should consider prohibiting non-authorized staff from being clients' main points of contact in the wake of Mazur. He explained that the days of routinely permitting paralegals, trainees, and other non-qualified staff to conduct litigation, even under supervision, are over. Justice Sheldon's judgment is unambiguous. Mere employment by an authorized firm does not confer the right to conduct reserved legal activities, and supervision does not cure the absence of individual authorization. The message is clear. Act now, conduct an urgent audit, revise policies and procedures, train staff, and engage with the SRA and professional indemnity insurers if necessary. Well, I don't think it is if necessary. I think it is necessary. You need to pick up the phone to them and say, what are you expecting from us? Do you want us to go through all our litigation files and then report a circumstance that may lead to a claim? Or are you basically having a sort of a benchmark where you say, well, beyond this, we don't want it? So, get the insurers to basically stand their ground and say, this is our position. Now then, we had some breaking news, which is good news. So CILEX litigation rights. It's effective immediately. So the Legal Services Board said it was going to approve standalone litigation rights, and it has. So CILEX people need to be contacting CILEX as quickly as possible and applying for the rights that they're entitled to. Processes are under review to maximize efficiency while maintaining standards. So if you are CILEX and you're affected by this, get in contact and get things sorted. What they have said is the first chartered legal execs with standalone litigation practice rights could be authorized in 6 weeks' time, with around 2,300 expected to apply for them in the next 18 months. I suspect it's not going to be 18 months. I think they're going to be flooded in the next month or two, because it's causing real havoc. And so I think people will want clarity as quickly as possible, particularly on the basis that, from what I'm hearing, a lot of people who are CILEX are being looked at for redundancy and things like that. So we really need to get, ahead of this. And so the regulators need to move fast. Moving on to something different now, the new TA6 form has been announced. We knew it was obviously on its way. It's going to be mandatory for CQS firms from March 26. And so have a look at what the Law Society's put there. The link is there for you to have a look at. It is going to be mandatory, as I say, for CQS firms from March. So make sure you are doing the right things there. We have received, as one of the providers of the relevant forms, we've received all the links and things, so they'll be all ready and up and ready to go on that. Legal Ombudsman in crisis. Yeah, it's asked for more money, but it is looking at changing some of its systems, because clearly the data shows it just isn't doing the right things. So when you look at the growing backlog, for example, it was looking at between 500 and 1,000 cases. The actual backlog is now over 3,000 and counting, as you can see. And it's looking for a 12% increase. One of the good things that I'm seeing, though, as you can see in the radical measures under consideration, is it's looking at charging upfront refundable fees. Well, we've all seen that one. as a solution for years and years and years. Why couldn't the Legal Ombudsman see this as well? Now, whether it actually implements it is a different thing. But I think that's going to cut their workload massively, because you do have a lot of people out there. And I was made aware the other day of a litigant in person who basically was putting themselves out on social media, in effect saying, did you know that law firms have to pay an LEO case fee of £400? So why don't you try your luck? Put in a complaint if you're a client of a law firm and see if you can get a couple of £100. And so there are people out there who are actively promoting, let's take the mick out of this system and see how much money we can get out of it. Well, hopefully, if they do decide to charge upfront refundable fees, there won't be a harm to those people with legitimate complaints, but it will certainly squeeze out those people like that litigant in person who is trying to take advantage of the system. So I think that is a really good move for once from the Legal Ombudsman. First tier complaints. So we've got some changes coming where you basically need to give your complaints procedure to the clients at different stages. So we've got at the conclusion of the matter, at the start of the matter, upon request when a complaint's made, and such like. You need to be making sure that you've reviewed your website so the complaints procedure is prominent. It's not hidden away in sort of back pages and things like that. And we now have a standardized definition of a complaint. So it's an oral or written expression of dissatisfaction. It's been around for ages, so I'm not quite sure why it needs to be standardized. But having read the thematic report, clearly there's a lot of firms who really couldn't determine what a complaint was and how you should handle them. So perhaps it is a good thing. So this is coming in around about the 16th of November, but it's got to be approved by the LSB yet. So that time frame may slip. But what they're also talking about is whenever they do decide to go live with this, there will be a 3-month implementation period. So you'll have time to, to sort of get your things in order and revamp your policies and procedures and things like that. For those of you who use our templates, policies and procedures, we are already on this. And as soon as we get the nod from the SRA and the Legal Services Board, we will be changing things. And so you won't need to worry about that. I did a LinkedIn post this morning around this because there's obviously a lot of activity around complaints. And so I thought, well, okay, we've got these people pushing all this stuff out. Let's see, in fact, how they perform on complaints. And so I had a look at Trustpilot because what the SRA was saying in its report was that firms should respond to all reviews on Trustpilot and other sites, particularly, as it's emphasized, negative ones that have been published online. And so it's basically saying you've got to go in and, in effect, you should be dealing with all negative complaints you might want to, or issues around service levels and things like that. And so you should be going on there. So that really is what prompted me to then have a look at, well, what's the SRA doing? What's the Legal Ombudsman doing? And Trustpilot basically came out having looked at the ratings that these two organisations have and put together what its views were. So the SRA doesn't respond to negative reviews and has a Trustpilot score of 1.1. Most reviewers were let down by their experience overall. Reviewers describe the company as incompetent, useless, and a waste of taxpayer funds. These are not my words. These are people who were reviewing it. Many consumers believe the company is biased and dishonest. People report that their complaints are often ignored or dismissed, leading to a sense of injustice and frustration. The overall sentiment suggests a strong consensus among reviewers that the company is failing to uphold its responsibilities. I then had a look at the Legal Ombudsman, and the Legal Ombudsman scored 0.1 better, so it was 1.2. with similar reviews. So you will see, if you want to go and have a look at the article that I put on LinkedIn this morning, you will see that, how can you regulate and how can you be an ombudsman and be telling people this is what you should be doing when you yourself do not do it? We should not be having a situation of do as we say, not as we do, situation. So have a look at that one. As I say, it's one of many articles I've done over the last couple of weeks. So here's the review. I'm not going to go through this. Again, I just talked a moment ago about what firms consider a complaint and things like that. So have a look at it in your own time, and we'll see what comes of all of that. The drinking culture problem. Now, this one came out of. I was listening to an SDT case the other day, and it was really interesting listening to some of the witnesses. And they were saying, oh, this particular person was doing this and that and the other. And so I thought, well, let's just have a look at this. So there is a real drinking culture problem out there, it appears, particularly down in down in London with all the big firms. But alcohol-centered networking events create structural barriers to career progression and exposes firms to significant regulatory, legal, and reputational risks. So you've got issues around those in recovery from alcohol dependency. So if you're basically saying, as was being said by one of these witnesses, we have no choice but to go, then, is there an issue there that you're holding somebody back because they're recovering from alcohol dependency? They're pregnant, so they can't drink. Those with religious beliefs, they can't drink. So are you forcing them to, are you then discriminating against them? Health conditions, caring responsibilities, those who simply choose not to drink. There shouldn't be pressure on people to drink. But what do we then see? And we've seen this for years and years and years. Sexual harassment, bullying escalates, discrimination, professional boundaries blur. And one of the reasons I wanted to put this up here was not just because I've been looking at, SDT cases and things like that, but also because we've got Christmas around the corner, and therefore we've got Christmas parties coming. And so I wanted to put the warning out there. You need to tell your staff that, yes, enjoy yourselves. And I used to do this when I was in practice. I used to send an email around to everybody and I'd say, yes, I'm Scrooge, but behave yourselves, enjoy yourselves, but don't do the wrong things. Don't come back in on Monday and find that you've got a police prosecution going on because of drunken disorderly, sexual harassment, whatever it is. Because in effect, I'm putting it bluntly, you're on your own because I've told you you should behave. And you clearly didn't take that on board. So protect yourselves. Yes, you might be seen as Scrooge, but better to be seen as Scrooge than then have everybody saying, but you didn't tell us, you didn't warn us, and all the rest of it. So, put that in play. Oh, AI, mentioned that earlier on. We'll be discussing this in the AI LinkedIn Live next week. But we have more cases going on around fake citations being generated. As I say, I'm now using AI on a daily basis, and I found issues with it. I can be talking to it and saying, this is who I am. In fact, in the settings, it has my name in it, and I'm sort of asking it questions. And as it's building up its sort of learning, and this is a secure system. It's not ChatGPT or anything. It's a secure system within our business. But I had it this morning. It basically called me a different name. And I said, well, where did you get that name from? And it couldn't really explain why. And I said, well, in future, use my name, but we'll see what goes on. So if you can't get those sorts of things right, then you have got to be very, very careful. One of the things that I also saw the other day, and I'm asking for views on this from AI experts at the moment, but there was somebody down in, I think it was the University of Auckland down in Australia, who's done some research looking at the savings that can be made by engaging AI against the costs that you then need to use to get people to check what AI is producing. And so I'm really looking at that one closely at the moment, because actually what he was saying was those costs are pretty equal. Now, if they're pretty equal, and I think it will be open to a lot of challenge, if they are pretty equal, then people will be saying, well, what's the point in AI then? So it's a big piece of work that is now going to go under extreme scrutiny. But anyway, I'm not saying don't use AI. As I say, I'm finding it really, really useful as long as you check what's going in and coming out and all the rest of it. And yes, it is saving me time. So I think it's worth its weight. But we'll see. For those of you in LLPs, you need to be having a talk with your accountants. You need to be looking at this, particularly watching the Chancellor's budget on I think it's the 26th of November, to see whether, in fact, this is put in play. But it looks as if she is going to be imposing a new charge on LLP members to help fill the £30 billion black hole that she has made, not the Tories, she has made. And I'm not taking any political sides there, just distinguishing between the two. But yeah, you need to have a look at that one in terms of how that might impact you going forward. Conveyancing reform, there is a lot of stuff going on around the conveyancing reforms at the moment. There's a live consultation going on at the moment. I am, in fact, a part of the conveyancing task force, and we are looking at putting in a consultation response to this. And my particular role is looking at it from sort of the compliance side. All the others are then looking at it from a conveyancing side. So, if you're a conveyancer, watch this space. And if you feel you want to put in your thoughts as well, then, please do. UK sanctions list, there has been a change there. So it is going to change from January. So it's going from the OFSI consolidated list to the UK's sanctions list. And so that will be your new source. So have a look at your firm-wide risk assessment, put it all in there, and say that you're aware of this particular change, and you will be adopting it as appropriate. Update your policies, controls, and procedures. Update your training, and go from there. New general license issued. So have a look at that one. It's another one for your firm-wide risk assessment, or if you have a separate sanctions list or sanctions firm-wide risk assessment, then put it in there. I think most people now have got a consolidated firm-wide risk assessment, so bob it in there. Annual review. So again, this is the OFSI annual review. It's just another one for your firm-wide risk assessment, just to say that you've read it, you have taken out anything that is of relevance to you. And as I have said before, the SRA, although they seem to have their own internal conflicts on this one, the SRA, and this is the advice I would follow, has said, even if you don't have anything to report, put something in there to say that you've read it and that you have, it isn't going to impact you. By leaving it empty, you could be criticised for not taking any note of these things. Struck-off solicitors. Yes, I'm talking about struck-off solicitors, and yes, there's a 9-month suspension in there, but I wanted to put this in there anyway because you can see that we've still got things going on there. That suspension one was woeful office supervision, and so there will be suspensions around that sort of thing. But we've got these naughty people, very naughty people, getting struck off for doing things with client money that they shouldn't be, and obviously other things that they shouldn't be doing. CV lies to reach the bar. So this was somebody, a junior solicitor, who basically lied on their CV. One would have thought that that had gone out with the arc since all these ministers had been caught lying, but quite clearly, that isn't the case. I have to say, it does really get in my craw when I sort of see things like this, and yet you then have a government minister saying he's a solicitor when he's not, and nothing happens to him. the SRA decides, don't have to worry about that. We'll move on from that. So where's the consistency in enforcement? It really does sort of stick on that basis. Okay. In terms of key compliance actions coming out of all of that, start preparing for the new complaint requirements, assess whether your PCPs and their implementation will be acceptable to the SRA. This is not just about saying we have a policy. The SRA will be doing a thematic review. It has not gone away as a consequence of going to the FCA, but they will be doing a thematic review, not to see whether you have the policy, but to see whether you have the policy and that it is being implemented on the ground. So they will be talking to other people to see, well, okay, this is your firm's policy. What do you understand from it? What actions do you take as a consequence of this? Consider the impact of the LLP reforms may have on your firm. So that could be a real big one for some firms. Update your firm-wide risk assessment as appropriate. And as I mentioned a few moments ago, think about self-reporting after Mesur. As I say, my best practice advice would be, let's put in a report. Let's hope that we get sympathy from the SRA. And I think if the SRA does decide to take anybody to task over that, I think there are good grounds for appeal to the Legal Services Board, to the Law Society, because if it is purely on the basis of this is what we were told, this is the way it's all been done up until now, how can you then start to say, well, actually, we're now going to go back on what we told, what we said and what we'd allowed the culture to become. So I think this is going to be a real interesting one to watch. But as I say, I think from a best advice perspective, I would be doing a self-report. Lots covered, as I say, and so, I'll go to questions. We have got some questions here. So Andrew has said, doesn't the reaction to Mesur that they got it right all along is fundamentally dishonest too? There should be a carefully drafted amnesty provided. Yeah, I totally agree. By their supervision guidance was followed. Yeah, I think it just reinforces what I've just said, Andrew. I totally agree with you. This is a mess of other people's making, and it seems that the profession itself, although the practitioners have fallen foul of what other people higher in the pay grade should have been looking at. Tony has said the definition of legal representative under CPR 2.3 is in direct contradiction to the Mesur judgment. Yeah, I think we're going to see a lot of things coming out of this, Tony. You and I have exchanged messages on LinkedIn, and obviously we had a chat down at the compliance conference. So, yeah, I think there's going to be a lot coming out of this. You've also said it would have been nice if the new CEO of the SRA, Sarah Rapson, would have made a special appearance at the conference just to boost morale. Yeah, I have to say, I was sort of questioning before I arrived, are we going to see the new CEO sitting up there with the chief executive on the basis that, the old one was going to be going in a few days' time? But whether he was put up there to sort of say, well, you're part of the apology. Yeah, but in my view, it should have been here's his head. But, we are where we are, as they say. So, I've already made representations to Sarah Rapson and said, look, why can we have a coffee and a chat and let's sort of talk about these different things? I haven't had anything back from her. I have to say it was purely via LinkedIn. But, let's get her in place. She's got a lot of work to do. And maybe she sort of picks up the phone and says, yep, let's have a chat. But who knows? I'm happy to talk to them if they want to talk to me. This is Debbie. Do you think it is possible that the LSB will not authorise the new complaint procedures? Sending complaint procedure again on completion, particularly in conveyancing, is really a terrible idea. It's impossible to please clients in conveyancing most of the time, and this will lead to more work for law firms, the LEO for unfounded complaints. Yeah, I totally agree, Debbie. What they're doing is just putting a red rag to a bull out there, and that leads to the likes of that litigant in person that I mentioned, where people will think, well, here's an easy couple of £100. We'll just complain, and the firm will say, well, we don't want to go to the legal ombudsman, so go away and take a couple of £100 with you. Yeah, will the Legal Services Board approve it? I hate to say it, but I think they will, it just beggars belief that nobody else puts out complaints procedures in the same way that the legal profession does. I keep on asking the questions on LinkedIn. If I was a patient in a hospital, as soon as I walk through, I am not given, whether I'm on a stretcher or not, I am not given a copy of the hospital's complaints procedure. I am not given it on exit. You'll be lucky if you get it when you do make a complaint. So, and that is a matter of life and death. So why are we doing it with the legal sector? It just, as I say, it beggars belief. But it seems to me that, we want to gold plate our regulation, and the regulators are falling for it left, right and centre. Let's have a look. Anonymous has put, is there any sign of the SRA source of funds thematic review yet? I suspect, the SRA keeps on talking about business as usual until the FCA takes over. But I do wonder whether they are now hurriedly looking at their plans on AML reviews and things like that, and whether we will actually see it. So I haven't seen anything yet, but I think I would say to you, work on the basis it's going to happen. Because I think if it doesn't happen with the SRA, it will happen with the FCA at some point. So, be ready for anything like that. Elena said, firms who act for commercial clients in volume matters will just annoy those clients by sending complaints info at the end of every matter. Yeah, I totally agree with you, Elaine. And what I would be doing is pointing the finger straight at the SRA and the legal ombudsman. Have a look at that one. Tony has kindly come back to say the thematic was published yesterday. I was working on the basis that it was a thematic they were going to be doing, and Tony's just reminded me it's a thematic that they have done. So I'm going to take a good look at that. Thanks very much indeed for that, Tony, and for the link as well. As I say, I've been really, really busy, so I obviously didn't get to that one in time, but thanks, Tony, for that. Okay, I think we're coming up to time. Can't see any more questions, but just because you can't ask them now doesn't mean you can't ask them offline. My email is on the front slide, so please do send us anything. So I'm going to cut things off there. Thanks very much indeed for attending. As I say, please do let me know what you think of the new slides. Not only whether, yes, they're acceptable, or no, they're not, let's go back. Or if you think they've got too much wording on them, then again, just let me know, and I'll tell the AI system to basically reduce the wording that I want to see on it. So it's not just a yes or a no, it's can you just change it, and then it'll look even better. So, as I say, thanks very much indeed for that. And as always, please do stay safe. Bye-bye.